You want to pass your real estate exam? Well, stay on here so that we can review national questions that apply to all 50 states and Texas state questions. So this is Wow Lillie Handy coming to you from San Antonio, Texas with YouTube Agent Prep to help you prep for your real estate exam anywhere in the USA. All right, so we're continuing with where we left off on Wednesday. And just want to show you the book that we use. This here, I have approval to use the Medling Father and Son team, Cusick and Hamilton authors, Texas Real Estate License Exam Prep. This book is available for 26 different states so far. They continue to add every year and they update them. You are able to find them on Amazon.com. I have a link down below in the description. And just to let you know that Amazon will pay me a fee should you buy through using my link. All right. So get ready, get set. And here we go. We're starting out with number 126. So these questions have to do with rights, interests, and estates ownership. So keep that in mind when reviewing these questions. Good morning, Crystal. Thank you for joining us here today. Let's pass that exam. I passed, right? Yes. A lot of students been passing lately. And after that, what do? Find a sponsor. And after that, you study more and learn how to work with sellers and buyers. Oops, number 26. Gosh, I was getting started with number 25. All right, there we go. And remember to participate during a class and type the correct answer, type the question number and the answer that you know best. Should anyone get the answer incorrect, then I'll review, I'll Google it to find different answers, whatever it takes to help you understand the material or read the answer from the book. Anybody watching the replay, hey, you may fast forward between questions as this class is designed to help students participate during this live. So Crystal says, I am passing before the year is over. Yes, I love it. I love it. I love it. That's the attitude. Okay. That's the attitude to have. Awesome. Good morning, Tanya. All right, here we go, you all. Type your answers in the chat. Okay, an estate at will is what? A, cannot be terminated. B, is terminated only if so stated in the lease's last will and testament, lessee's last will and testament. C, terminates on the death of lessor or lessee. D, terminates on the date specified in the lease agreement. So Eddie, I've got a brother named Eddie. It's Edelmiro, and we call him Eddie. I take the test for the third time on Tuesday. Hey, a lot of times, third time is a charm, right? So no fear, just practice all your questions and answers until you get 100. Don't stop at 80%, 90%. Keep taking the same exam until you score 100 on it. That's what I did when I was prepping for my exam because I feared in 2013, multiple choice questions always had. And study a lot of vocabulary, okay? Learn it, memorize it, whatever it takes. Okay, type your answer in the chat. So an estate at will. What is an estate at will? Can it be terminated or not? Is it terminated only if so stated in the lessee's last will and testament, or does it terminate on the death of lessor or lessee, or it terminates on the date specified in the lease agreement? An estate at will. Okay, so far we have C, D, C. All right, this is an estate at will, so it's not necessarily a lease agreement between a landlord and a tenant. It's between an owner, okay, and a person that gets to live there, okay, at will till their death do us part. So C is the answer. Terminates on the death of lessor or lessee, right? And the lessor is the owner who granted that individual to stay there for the rest of their life, or a lessee who's the actual person living on the property and has the two of the bundle of rights, the right to use and possess. Hi, Delta. Good morning. So the answer is C here. Terminates on the death of a lessor or lessee. That's what an estate at will is. So real estate is you have real interest in a piece of an estate, right? Land, its improvements. So an interest at will, right? They terminates at death or of lessor, the owner, or the lessee. So very good. For those of you that, let's see, did I say good morning to Crystal? If not, well, good morning. Okay, hold on. I'm typing the answers also on Facebook. I love the fact that all of you are on YouTube. You help my channel by doing that. The analytics. So one of these days you might be interested in creating a YouTube channel. That's the number one social media because it's an educational channel. All right, number 27. And when you do, I plan to develop a little boot camp to help individuals get started with a channel or refer you to others that I learned from. All right, number 27. A tenant continues to occupy an apartment after lease expiration without the consent of the landlord. This type of estate is called, okay, remember they have an interest in that property. So what kind of an estate is this? A, an estate at sufferance. B, a holdover estate. C, a canceled leasehold. Or D, a hostile leasehold. Check it out, Mr. Eddie and Delta. Quick on their answers. So far, we've got 2 A's, 3 A's. So anyone who just joined, we're doing national questions that apply to all 50 states. And good morning. Yes, the answer is A, an estate at sufferance. And you're like, wow, why is somebody suffering? Well, it refers to the landlord is suffering because they have a tenant that is staying on the property after the lease expired and they shouldn't be staying there. So now the landlord has to go through an eviction process. Okay, number 20, excuse me, number 28. So I try to accommodate for anyone that's watching on a cell phone because it ends up looking really small on a cell phone. However, it still works pretty good. Okay, number 28. A tenant without a lease has been sending the landlord monthly rent checks and the landlord continues to accept the payments. What kind of a leasehold estate exists? A, estate for years. B, estate from period to period. C, estate at will. Or D, estate at sufferance. So we already know it's not going to be estate at sufferance, right? Because we just reviewed that question. So is it A, B, or C? I would take another attempt, Eddie. Hi, Lisbeth. Thank you for joining in on YouTube. And it's not C. So I said it wasn't D, and now I said take another attempt because it's not A and it's not C. So what does that leave? That leaves B. It's an estate from period to period. Okay, month to month. So leases typically have a clause that should the lease expire, it can convert to a month-to-month lease. So that is an estate. They have an interest in that rental from period to period, month to month, week to week, day to day, however the lease is specified. So we just did estate for will at will, right? So that terminates when someone passes away. So it's not that one. Okay. Good morning, Miss Cindy. You know, Cindy has already passed the national exam, but she still attends. And, you know, and that's a good thing because you keep learning the material better. And some of the explanations could actually help you for the actual Texas state exam or some other state exam for those of you that are attending that are here from other states. So it's understanding, you know, little keywords on what the question asks and, you know, what little keyword can help you get the right answer or get the wrong answer. There's usually little words here. So here, a tenant without a lease. So the lease expired, they no longer have a lease, or it was a word verbal lease, right? A lease less than a year can be verbal. And if it's month to month, it can be verbal or it can be written, either way. And they're still sending the landlord checks and the landlord continues to accept. So there is a mutual agreement. So it's a leasehold because they're leasing the property. They don't own it, right? It's an estate. They have an interest in that property. So it is from period to period. Okay. So, yeah, so here you get congrats, Cindy. That's congrats. And you have at Crystal XO. All right. So the answer here was what? B, right? An estate at will. I'm sorry, an estate from period to period. What am I talking about? I'll show it so that you make sure for those watching the replay. We're going to what? Number 29. All right, number 29. A fee or life estate is held by an individual. This form of estate is referred to as A or an A, tenancy and severalty, B, tenancy by the entireties, C, absolute fee simple, or D, legal fee simple. We discussed legal and conventional type of fee simple on Wednesday. So if you're not sure about that, go back to Wednesday's video and replay. So a fee or life estate. So when they say fee, they're talking about like a fee simple, like, you know, fee simple here, when you have all the bundle of rights. So a fee or life estate is held by an individual, one person or one entity. This form of an estate is referred to as, yes, y'all are on a roll, tenancy in severalty, right? Because severalty is ownership by one person or one entity, right? An LLC, a partnership, a corporation. And where there's a general partnership, you have that general partnership person, the general person of it can become the brokerage of that partnership, right? We discussed that one on Wednesday. Very good. So there are 4 different types of ownership. Okay. So tenancy in severalty, one person, one entity. Tenancy in common, 2 individuals or more. 2 or more. Okay. And they don't have to have same percentage of interest, but they have whole ownership. So they get to use and possess and enjoy the whole property, but have a different percentage of ownership. And it could be 50-50, 30, 40, 60, 30, 70, 20, 80, 10, 90. Okay. So different percentage of ownership, equal or different. And then you have joint tenancy, right? So you have joints, right? Joints. And so joint tenancy has to meet 4 conditions, right? 4 conditions. TTIP, right? Time, title, interest, possession. TTIP, T-tip, time. So to be a joint tenancy, it has to meet those 4 conditions. So keep that ingrained in your mind. Joint tenancy, you have multiple joints in your body and they all work together. Okay, so they purchased the property at the same time, took ownership at the same type of title. They have the same interest, equal percentage interest, and equal possession. And then the 4th one is for married individuals. That's 2 individuals, right? So that is for married couples, and they have joint ownership. In most states, it is tenants by the entirety. In Texas, it is tenancy common community property. I believe there are 9 community property states. And that'll be determined by the courts, or tenancy by the entirety. Both parties equally have 50-50%. One of them dies, the other one gets their share. So just a review on how many types of ownership. Type it in the chat. How many types of ownership? Type that number in the chat, please. Come on, come on. How many types of ownership did I review? There are 4 very ownership. Very good. Awesome, awesome, awesome. All right, number 30. Six people enjoy an indivisible interest. So they have an interest that is not dividable. However, any of the owners may sell or transfer his or her interest without consent of the others. This form of ownership is so 6 people have identical interest in a property and indivisible interest. However, any of them may sell or transfer his or her property without consent of the others. What type of ownership is that? I didn't explain that when describing the 4 different ones. This one is not T-tip, Crystal, and thank you for typing that. T-tip. So T-tip is time, title, interest, possession. That's for tenants by the joint tenancy. Joint tenancy. However, this answer is not joint tenancy. Reason being, so I'll let you all type some answers. So Miss Cindy, which answer did you mean? 30 A, B, C, or D? We can say our ABCs, ABCs. So which one is it? A, B, C, or D? When you have 6 individuals, indivisible interest, however, they can sell it without the permission of the other one. You can't see the question? Oh, yeah, it froze for a moment. Yes, it's back on. Issues with internet today. Because even my YouTube channel has the wheel of death that we used to call it for Apple computers. All right, can y'all see it now? Because when it freezes, it also freezes for me. And on YouTube, it's showing number 29. It's frozen because there is a delay between here and YouTube here and Facebook, at least a 30-second, 10 to 15-second delay. So let's see, refresh your screen. Because it's at the end of, I'm noticing on YouTube that it's showing 29 and I'm actually displaying number 30. Okay, I refreshed my screen, okay, on YouTube and I now see 30. So I have multiple screens going on so that I can see what you all are seeing and seeing the delay or when it gets stuck. So let me know that you see number 30 now. Because I am seeing it. So I'll repeat the question. So listen carefully. 6 individuals with identical rights in a property. So they have identical rights and enjoy an indivisible interest, means they get to enjoy the whole property. They don't divide it into pieces. And YouTube is refreshing again. However, any of the owners may sell or transfer their interest without the consent of the others. So what type of ownership do they have? There's only one accurate answer. So remember, there are 2 of the ownerships are 2 or more individuals. The other 2 are not. So it's either A or C. The fact that they can transfer or sell their property without the others' agreement means it is tenancy in common, which is C. Okay, so that is correct for those of you that answered C. It is tenancy in common. They have everything in common, including the right to sell it without the permission of the others. They all get the right to possess it and enjoy it, and each one can sell their portion, which could be a different percentage. There are 6 individuals, so one of them could own 50% and the other 5 are divided, okay, by 10% each. So different percentages. They get to enjoy the whole property, okay? And one of them can decide, hey, you know what? I want to sell my share. So that is absolutely correct. 130 is C, tenancy in common. So why is it not A? Because in joint tenancy, they have exact equal interest ownership. However, they cannot sell without the consent of the other joint owners. Okay, and if one of them passes away, their percentage goes divided equally amongst the other joint owners. Let's see, passes to the owner. This form of ownership is, okay, I'm not sure what exactly you mean. So on joint tenancy, if one person decides to sell and all the others agree, they have to give the first right of refusal to the other joint owners. And if those other owners says, yeah, go ahead and sell it, they'll sell it. That new owner of that share becomes a tenant in common with the other 3 joint tenants. All right, very good. So tenancy in common. All right, number 31. All right, so that's not going to work. It's going to have to be smaller. Oh, not so small. There we go. All right, 31. The 4 unities required to create a joint tenancy includes which of the following conditions? Just described them, right? A, parties must acquire respective interests at the same time. B, parties must be residents at the same state at the time of acquiring the interest. C, parties must be family members. Or D, parties must have joint financial responsibility. So which one meets at least one of the conditions? Of the what? 4 unities. That's what it means. It meets 4 conditions. TTIP. T-tip. All right, so far we have Lisbeth and Delta with A, Eddie with A. In fact, I spoke with my brother Eddie yesterday. He's really short, man. You know, he's only 6'4". Ha ha ha. Love my brothers. I have 6 older brothers. All right, yes, the answer is A. Parties must acquire respective interests at the same time. Time, title, interest, possession at the same time. Very good. So Eddie is 5'6". Interesting. My dad was 5'6". My dad was 5'6", and my mom was 5'9". So quite a few of us are real tall, including me. For a woman, you know, I'm a tall one. But nowadays, man, you got young women that are 6 feet, 6'4", basketball players. Woohoo! All right, so the answer there was A. Everybody got that right. Oops. All right, number 32. Unlike tenants in common, joint tenants have what? A, own district portions, not district, sorry. Own distinct portions of the physical property. B, cannot will their interest to a party outside the tenancy. C, may own unequal shares of the property. Or D, cannot encumber their interest to outside parties. So T-tip, time, title, interest, possession. How does 32 then answer that? So unlike tenants in common, okay, joint tenants meet what? Do they own distinct portions, you know, different portions? They cannot will their interest to a party outside the tenancy. May own unequal shares. And D, cannot encumber their interest to outside parties. And so what does that leave? No. Oh, I thought somebody had typed A. That was me. No, not A. No. Try it. Take another attempt, Miss Lisbeth. Come on, A, B, C, or D. No. Okay, y'all. The answer is B. Let me repeat the conditions of joint tenancy. Okay, what did I say about joint tenancy? Tenancy in common, which they're saying, unlike tenants in common, which is 2 or more, and they can have different interests, right? Different percentage of interest, and they can sell without the other one approving, the other partners. Joint tenants, okay, think of joints, okay? it's not easy to take an arm off the shoulder, right? So they're tied together for a purpose. They have to buy it at the same time. They have equal interest, equal percentage. Okay. They have 100% possession of the property and use of the property. And fourth, so time, title, interest, possession. Okay, so I repeated that. They have equal interest. So if there's 4 parties, each owns 25%, and they cannot sell their interest to an outside party without the others agreeing. Okay, it is a very tight relationship. Okay, you have a joint that's very tight relationship. So if this part of the body decides to release this joint, okay, like if you have a major accident at a mountain going downhill, right? Well, it releases it, right? So that it doesn't break. However, otherwise, it's joint together very tightly. Therefore, they cannot will their interest to another party outside of that joint relationship. Okay, so let's see. Everyone except for Tanya answered something else. Tanya answered B. Great. So A says own distinct portions. Okay, you all want to make it very clear. We do not own, when we own property together, we don't own a distinct portion. So if you live in a house, unless you're dividing the house like some individuals in movies, going through a divorce, they say, okay, you use that half of the house, I'll use this half of the house. Well, hopefully they each has a bathroom, right? And a bedroom or in a kitchen. So no, you cannot divide how you each use the property. It is distinct. Now, if they have an acre and they have 2 homes on it, yes, right? But they have the right to use and possess all the property, all the acreage, the entire house, not just a distinct portion, not just one little area. Okay, so that it's not A. No own distinct portion. No, no, no. C, may own unequal shares. No. When there is joint tenants, they own equal shares. 3 partners, 33 and a third, 33 and a third, 33 and a third. 10 partners, 10% each. 4 partners, 4 joint tenants, 25% each. Equal. They took possession at the same time, the same title way. They have 100% possession and they have equal interest. Write that down over and over and over. All right, so let's see. What other answer did someone? So most of you answered A and C. No, not unequal. That's for tenants in common. So reading the answer carefully, they're asking for what is joint tenants. So unlike tenants in common, where they can have unequal interest, they can sell their share without the permission of the other, joint tenants cannot. Okay, joint tenant has a very strict relationship, okay? Let me know that you understand. If you don't, I'll Google it and show you different ways of understanding. Or actually, let me do some of that. So internet is having issues, so YouTube also, okay? Joint tenants. So let me see here. What else I can describe? Okay. So Google it. So another thing about joint tenants that you see here, they have a right of survivorship. And that's what it means, that if one of them dies, their portion goes to the other. Yeah, so I figured that's what happened, Lisbeth, that you were thinking they were asking for tenants in common versus joint tenants because of how the question started. But joint tenants is when two or more people jointly own a piece of real estate. There is presumption that the ownership is in the form of tenancy in common, okay, but it's not. Okay, when one joint owner under a tenancy in common dies, then owner's interest in that property passes to that owner's heirs or devices. That's in tenancy in common, not in joint tenancy. So let's put the conditions of joint tenancy. Or I should have said unities, like the okay, so it keeps saying in Texas, and it doesn't have to be in Texas. This is a national, okay? So let's see, the most important characteristics. I wanted them to list it in a list, but you see here, this means that upon the death of one owner, that one owner's share goes to the other surviving owners. So a joint tenant's interest is therefore not freely divisible at will. They can't do what they want with their share without the other joint tenants agreeing. So it says, unlike most states, Texas does not automatically recognize joint tenancy as having a right of survivorship. So sometimes Texas, being the second largest state, right? It's more conservative, so has some other things. That's why we have common law and community property versus tenants by the entirety. So let's see here. What are 4 unities to be required to create a joint tenancy? So I wanted a list. Okay, I want a list. What is the disadvantage? Can 4 people be joint tenants? Yes. So what is the purpose of joint tenants? To have equal rights to the whole property. So it's as joint tenants, sometimes called beneficial joint tenants. They have equal rights, equal interest, equal possession, and the right of survivorship, which is another vocabulary, which means if one of them dies, or when one of them dies, their share goes to the surviving partners, the surviving tenants. So that's what tenancy by the entirety for married couples also has survivorship. Out of the four tenancies, there are 2 that have the right of survivorship. Joint tenant is 1, means it has to go to the other tenants, the other partners, when one of them dies. If it's a married couple, when one dies, it goes to the spouse. It doesn't get divided into the heirs. That's what happens in severalty or tenants in common. So then, I wanted them to list the 4 different conditions of joint tenancy. But it's not. Let me see if it does it here. So you see right of survivorship, pros and cons. So anyway, this is how I research things. Okay, whenever you can't find an answer, Google it. Because when you Google it, Google will give you what are other individuals like us asking about that particular topic. And you go here, people ask. Okay, so what are 4 unities required by joint tenants? Well, I wanted them to list it. Okay, so it's time, title, interest, possession, T-tip. So let's say describe or list. I want a list, right? List for unities of joint tenants. Let's see if it lists them this way. Good morning, God is in you or something like that. Okay, so here it is. At the present time, whenever a joint tenancy prevails as a form of ownership, these four unities are of interest. Okay, and what are they? Unity of possession, 100% possession. All joint tenancies hold an undivided right of possession. Unity of interest. All joint tenants hold equal ownership interest. Unity of time. They bought it at the same time, the same day, and they took title in the same way. They could have all inherited it. They could have all got it as a conveyance, or they bought it at the same time. So they took title, the same type of title. Okay. Those are extremely important for this type of ownership. And the other one is survivorship. It's one of the four that has survivorship. Okay. Only joint tenants and tenancy by the entirety have survivorship, meaning one dies, it goes to the others. Okay. Okay. All right. I love this. Good morning. I'm going to pass this test. In fact, I'm going to ask you to restate it. I passed this test. I passed it. You already did it. Visualize it. Think it. Cheer it. I passed. I passed. I passed. Ask, believe, and receive. All right. So you understand. Great. Good. Moving to the next question. So the answer here was B, cannot will their interest to the party outside the tenancy. All right, number 33. Which of the following life estates is created by operation of law rather than by the owner? Okay, so it happens automatically by the owner. Yes, this is better. I passed this test. Yes. So which one is life estate is created by operation of law rather than by the owner? A, conventional life estate. B, ordinary life estate. C, legal life estate. Or D, community property life estate. So keyword, created by law, created by operation of law, not by the owner. So think about it while I refresh my coffee. Okay, so think about that. All right, did you think it through? Awesome. Awesome, awesome, awesome. Yes, the answer is C, legal life estate. Because it's created by law. What's an example of legal life estate? We discussed it on Wednesday. So if anyone wants to go back on that, you can go and review Wednesday's prep class video. So legal life estate means that it is automatic. And one of the types of ownership or conditions that's automatic in a state is homestead. Okay, in the state of Texas, and other states, homestead, when it's property is purchased by an individual or a couple or family, that is their homestead. It's protected. It's automatic. Now, in order to get the exemption of the reduction in certain taxes, property taxes, they've got to file a form to say, hey, I want to apply for the exemption. That's not automatic. It is automatic. However, it won't show up in the reduction of property taxes until a form is filed. Very good. Number 34. Which of the following is true of a homestead? Oh my goodness. See, some of the prior questions can help a future, and sometimes future questions can have a prior question. So when you're at the exam, and if you're not totally sure about an answer, click it for review, come back to it later. Which of the following is true of a homestead? A homestead interest cannot be conveyed by one spouse. B, a homestead interest cannot be passed to the children of the head of the household. C, a homestead interest is a form of conventional life estate. Or D, a homestead is a primary or secondary residence occupied by a family. The YouTube channel, you all don't see number 34 yet, huh? Because I don't see it on my YouTube. If you don't, refresh your screen, okay? So far we have A from Cindy. So which one is true about homestead? Yes, you see it. Okay, very good. I see it now too, but I have to refresh my screen. All right, so Cindy and Eddie have A for 34. I'll give you a moment for others to answer. So anybody watching the replay, these are national questions that apply to all 50 states. And if you're watching it, the replay, hey, just fast forward between questions. Yes, the answer is A. A homestead interest cannot be conveyed by one spouse. Okay, because it belongs to the two, that is their primary residence. And when you have tenancy by entirety or community property, a spouse cannot sell their portion without the agreement of the other. And that includes the homestead. Because the homestead protects owners from certain creditors, like predators, right? And there's a lot of predators in today's world. There have always been in existence. However, with the internet and technology and all that, there's a lot more. Okay, homestead interest cannot be conveyed by one spouse. Okay, number 35. I was going to make a joke. Okay, so how many spouses can you have? Well, in certain states or certain cultures or religions, you can have more than one spouse, right? Here in the US, one. So I would have said a spouse. Number 35, a tenant in common. Okay, because we're discussing in these questions, we're discussing rights of ownership, interest in estates, and other types of ownership. So rights, interest in estates, and ownership. So this is a type, one of the 4 types of ownership. Tenant in common can A, sell or transfer their interest without the consent of the other tenants in common. B, use his or her interest in the estate to encumber the entire estate. C, sell, encumber, or transfer his or her interest only to the other tenants in common. Or D, sell, encumber, or transfer his or her interest only with the consent of all the others. That's probably what it says, the other tenant in common. Awesome. I think all of you understand it now. So it is A, sell or transfer. So tenant in common can do what? Sell or transfer their interest without the consent of one of the other tenants in common. Because this is two or more, they have equal possession, equal or unequal interest. There's no survivorship and they can transfer it. Now, they cannot encumber it, meaning they cannot go get a lien on the whole property unless they all together do it. It's probably not a good idea. Okay, we've done questions. I'm going to ask you. I've got the time. If you've got the time, we can do more questions for national. Quickly type on the chat if you want me to do more national questions that apply to all 50 states. In the meantime, that you make that decision and type it in the chat. If this is your first time in this channel, on my channel, YouTube Agent Prep, remember to tap that subscribe button, click that little bell so you're the first to get notified every time I go live or I upload a new video, and like this video if you find it useful or helpful. So there are many of you here on YouTube. Come on, send me some love. Click that subscribe button. All of you are on YouTube. Love it, love it, love it. Let me see 10 not subscribes, I mean 10 thumbs up. All right, so yes, please, more national questions. Okay, we've got yes, yes, yes. So we'll do a few more national questions. Thank you for your answers. Which of the 36, which of the following would be considered community property? Common property, community property, as per certain states. Delta, I'm going to do a few more national since the first two individuals that answered says more national. So it'll go by quickly, okay? So which of the following would be considered community property? A, property acquired before marriage. B, a motorcycle bought after the marriage with separate property funds. C, income derived from community property. Or D, a mother's heirloom wedding ring gifted to the wife after her wedding. Yes, it keeps freezing. And right now on my YouTube, it shows number 35, and I'm actually on number 36. So refresh your screen if that's the case. And when the weather is cloudy or it's raining or stuff, there will be a delay. Okay, I can see 36 now, so you should be able to see 36 if you refresh your screen. So on number 36, since you're just being able to see the question, again, which of the following would be considered community property? Property acquired before marriage. B, a motorcycle bought after the marriage with separate property funds. C, income derived from community property. Or D, a mother's heirloom wedding ring gifted to the wife after her wedding. All right, here comes the answers. Here comes the judge. Here comes the judge. CCC. Oui, monsieur. Hey, I like the dog on your profile picture, Tanya. I love animals. Yes, the answer is C, income derived from community property. So if there was a rental or a property that was owned prior to marriage, and while they are married now, the property is being rented, they've got income coming in from it, rental income every month, then that is considered community property because they're receiving the income while they are married, within the marriage. However, the property belongs to one of the spouses only, whoever owned it prior to the marriage. Now, should they start doing upgrades on the property, improvements, adding, the cost of those improvements now are shared equally. So the ownership of that improvement is shared equally. So how it happens is, should they ever sell it, a percentage will be taken of the whole property, and that will be divided amongst the two. The other percentage belongs to the original owner. I better type the right answer on Facebook. Okay, very good. So 136C. And when all of you know friends while you're taking your school, your classes, or prepping or study groups, hey, I ask you to recommend my channel. There's a lot of good channels out there. However, I ask you a favor to, hey, relay my channel to others, send them the link so that they join. Okay, so I've got a question and we'll take time to answer that question. So Delta says, what would happen if you put a property under an LLC after marriage? Well, if it was owned if it was purchased while you are married, then the LLC, then even if it's an LLC, okay, it'll belong to the two. They'll probably want to put the two of them on the LLC. Now, if the property was in an LLC prior, or they add to the property they owned prior to the LLC, and it becomes an LLC in order to keep it separate before they start making any improvements, then the LLC owns it. Okay, it's not community property between the two or three or four. Okay, but this is usually in a marriage situation, okay, or it is in a marriage situation. So if it's put on an LLC prior to marriage, then the LLC owns that property. Any proceeds or investments have to be separate from the couple's income or expenses. Okay, that is a business expense, a business ownership, and so it's owned by that entity. If it's done after the marriage, and depends on the condition. So you're saying, what happens if it's done after the marriage? Well, it depends. Did one of them own it prior to the marriage? Did they buy it during the marriage? Or how was it acquired? Okay, and how did they put it in an LLC? Because you can have an LLC, and have several individuals under that LLC. So it would have to be more descriptive, and that would go to an attorney to explain that. Okay, because there's a lot of different types. So number 37, woohoo, look at this. Lisbeth is moving on. Number 37, when real property is held in a land trust, who controls the property? Okay, keyword, trust. Okay, trust. In a land trust, who controls the property? Whenever there's a trust, there are at least three parties, right? Trustor, trustee, and so is it A, the trustor, B, the trustee, C, the beneficiary, or D, the mortgagee? So who controls the trust, okay, the real property, when there is a trust? No, not B. It's not a trustee. So the answer here is the beneficiary. Okay, it says who controls the property. Trustees manage the property. They don't control it. The owner is the beneficiary. Okay, and that is the lender, whoever provided the funds. The trustor is the new owner. However, there's a loan. Otherwise, there wouldn't be a trust or trustee or beneficiary. Okay, it's a land trust. So there are three parties. The trustee is the one that holds on to the title in the state of Texas, because we have a deed of trust type of mortgage, and many other states do also. The beneficiary is who actually owns it and controls it. They're the ones who let the trustee manage it should there be a default by the trustor, and they can pursue with a foreclosure. Okay, send out notices. Okay, and send out, well, actually, the lender, the trustee gets involved whenever there's a major default. Okay, so the owner is the controller of the property. The trustee holds the title for the benefit of the beneficiary. Who benefits? The beneficiary. They're the owner. Okay, so real property, real estate and its improvements, is held in a land trust. So a land trust is when you own a property. It's a process of multi-level asset protection. I have owned several land trusts. When I want to protect who owns the property, then we do a land trust, and we put it in the name of the street, the name of somebody other than our last name. Because if we're protecting the ownership of that. If somebody is going to want to sue us, they're going to have to go hire an attorney, somebody to do the research, a title company, and most people aren't going to want to spend a lot of money unless it's, a very, 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 very expensive property, or it's worth it a lot to them. So the answer is the beneficiary. Who benefits from the ownership of that land, and who controls it? It is the beneficiary. That is the owner. That's the lender, or a hard money lender. So the trustees in many cases, okay, is an attorney, because they can follow the laws and the description of the deed of trust. The trustor is the borrower, is the new owner. Okay, however, they don't control it when there is a land trust. Okay, the trustor in a land trust could be an LLC. It could, and a trustee in a land trust could be an individual that we trust. Doesn't have to be an attorney. It could be an accountant. It can be someone else that we trust. And the beneficiary is the actual owner. It could be an individual that, owns it free and clear and sold it on owner finance and things like that. So that's a lot of times when a land trust is used. When an owner purchases a property, or the lender, and they sell it on owner finance. So it's like a land contract. However, in a land contract, the title is not conveyed. In a land trust, title is conveyed to the trustor. That's the new owner. However, the beneficiary probably is the carrying the note, okay, the promissory note, and the trustor still owes them. The trustee, my trustees, were usually an individual that I really trusted, not a family member that had the same last name, but someone that I trusted with a different name, so that it'll be difficult for someone to find the real owner. And these are laws created by the government and for IRS purposes, and to protect your assets, investment assets. So did I type the answer? Not yet. Oh, yeah, I did. Okay, so did y'all get that? I think most of you answered C. We have 1B, the trustee. No, that's the person that the owner trusts to follow through with what the deed of trust states. Similar to a mortgage, okay? So whenever there's a trust, there are three parties: trustor, trustee, and beneficiary. All right, number 38. That's not going to work. Oh, come on. Okay, there we go. 38. In a community property state, there are 9 of them. John marries Patricia. Prior to the marriage, John owned an SUV. And during the marriage, John bought a Buick. John and Patricia bought a second property and with money earned from Patricia's job. And each individual received a motorcycle from Patricia's uncle as a gift. What property is community property in this marriage? So which property do they both have interest in? A, the SUV, the Buick, and the second property. B, the SUV, the Buick, the second property, and the motorcycles. C, the Buick and the second property. Or D, the Buick, the second property, and the motorcycles. So what does it say? John marries in a community property state. So prior to marriage, John owned an SUV. John, prior to marriage. During the marriage, they bought a Buick. John and Patricia bought a second property with money earned from Patricia's job. All that is community property. Each received a motorcycle as a gift. So which ones are considered community property during the marriage? All right, so far it is not D. Take another attempt. Because there are 2 motorcycles. See, it says each individual received a motorcycle, but how? As a gift. Good. Change your answers. Gifts are not community property. So the answer is yes, C, the Buick and the second property. Why? It says John bought a Buick. It was during the marriage. That's other important feature. During the marriage, John bought a Buick. John and Patricia bought a second property. Doesn't matter whose money it was, Patricia's or John's, it's during the marriage. Then it belongs to both. So the Buick and the second property is community property. So you could have ignored, the rest of the question. It says during the marriage, that is considered community property. They got a Buick and they got a second house. The other was a gift. Gift are not community property. And if they receive money from a personal insurance, job insurance, accidental insurance from their own individual, policy that they owned, that is their own money. That is not community property. Because if it's a major accident and they have lifetime disabilities or whatever, that person needs that money. That is their individual money. Oh, good. Glad you switch. Sometimes it's good to switch an answer. However, whenever you're in doubt, if you answered the question, click it for review during the exam and come back to it later, because a future question may help you answer it, and a prior question that you maybe forgot about could answer that particular question. So always click it for review and then review it after you're done with all the questions. Or as soon as you see another question that helps you, go back and change it. I have done that. I wish I had known some of the things that I have learned from doing these prep classes about how to select the correct answer. I was terrible. I was afraid, of multiple choices. So I understand when you feel that way. However, that's why you're preparing through other sources, not just by yourself. Because you hear what others have to say, not just what's written in the book. Sometimes we have to view it, see it, to understand it. I'm a visual person. I like to see. I like to view, not just words. Number 39. Which of the following is true of a cooperative? What is a cooperative? So lots of vocabularies we've been going through. A cooperative may hold an owner liable for the unpaid operating expenses of other tenants. B, the owners have a fee simple interest in the airspace of their respective apartments. C, owners may sublease their apartments even if they sell their stock in the cooperative. Or D, the proprietary lease is guaranteed to have a fixed rate of rent over the life of the lease term. So what is a cooperative? So there's a difference between a cooperative, okay, and a condominium. So type your answer in the chat. So cooperative is more business oriented versus individual. It is not B. So take another attempt. That is B is an answer for a condo. And the airspace they're talking about is their respective unit, the space inside their condo. So it is not B. So in this case, they mention cooperative in one of the answers, okay? So the answer here, but that's not always the case. Sometimes when they do that, the answer is wrong. So in this case, A is the answer. A cooperative may hold an owner liable for the unpaid operating expenses of other tenants. So let me type the answers here and then I'll go back and explain a little bit. So since the corporation owns, okay, an undivided interest in the cooperative property, cooperation, debts and financial obligations apply to the property as a whole, not an individual unit, okay, in a condominium. So here's a key difference between cooperative and condominium. Do you all see that on your screen on YouTube? I don't see it yet. I'm refreshing it. So let me know that you see. I Googled it, but just so that I could show you. Okay, there it is. So the difference between a condo and a cooperative is the ownership structure. When you buy a condo, you own the unit and a percentage of the common space. The common space is the outdoors, right? The community that you get to walk around with, the pool, the community center, tennis court, basketball courts, whatever they have in common. And there's a condominium homeowner association due fee every month. When you buy a co-op, a cooperative, cooperation, you actually purchase a share of a property and you lease. Your lease enables you to live in it. So you own a share of the cooperative and then you have a lease for that particular unit. So everyone is responsible, okay, for the repair of that cooperative or expenses of that cooperative. Okay, got it. Very good. So condo, you just own that unit and pay dues for the rest of the area. Here, you own a share, okay, of the ownership, okay, and pay part of the expenses. And you can lease a unit for a certain period of time. So all these different factors, okay, into a cooperative. So go back to vocabulary if you didn't quite understand it and review vocabulary. And so remember, I have lots of vocabulary videos on this channel under the vocabulary playlist. Okay, Eddie understands. Yes. All right, number 40. Which of the following is true of a tenancy in common? They have something in common or things in common, but what do they not have? So A, the co-owners must be related. B, the owners enjoy an indivisible interest. C, the tenants must acquire their interest at the same time. D, the tenants may pay equal amounts for their interest in the estate. So which one is the best answer? Sometimes there are more than one good answer. However, there is one best answer. So this will be the last national question for those of you watching national that applies to all 50 states. So keywords to remember in any types of ownership. You don't own just a portion of the property or get to use a portion of the property or possess a portion of it. There is an indivisible interest. Okay, they have an interest in that piece of real estate, in that estate. So they have either a percentage ownership, however, they get to possess and enjoy the whole property. No, it is not D. The answer is B. The owners enjoy an indivisible interest. And when it talks about their indivisible interest, it means that they can enjoy the whole property. They have an interest in the whole property, not the interest in ownership. In a tenancy in common, they can have it, they say undivided interest, indivisible interest. So you don't divide the property into pieces for each owner. However, you do divide the ownership, the percentage of financial ownership could be different or could be the same. Okay, so you got it. So indivisible, undivided, okay, similar. They have 100% interest in possessing the whole property. However, financially, they have equal or different interest. And then the third key factor here is that it does not have survivorship. One of them dies, it goes to their heirs or to whoever they will it to. And they don't need the permission or the agreement of the other common owners. Okay, so any questions on estates, ownership, and interest and rights? Okay, interest in estates, what kind of interest? 100, undividable, indivisible interest, percentage, financial. So there's two types of interest, financial interest and use interest. Two different types. Financial is one aspect. The use of the property, they have 100% use, undivided interest, indivisible interest. Okay. So let me see, any questions? So we will move on to Texas states. So anybody who's here from other states, hey, you're welcome to stay on, because just pointing out little key factors could help in your questions for your, for your particular state. However, when it comes to law and state specific, okay, it'll be different. So, you know, national applies to all. And so this is Kindle. Kindle. So I buy books from this author in Kindle. And I'll buy some other ones, too. However, I'm not using them here. Okay, Eddie is heading out. I'm in New Mexico. All right, Eddie, New Mexico. Thank you so much. I'll see you again. Yes, next day is Monday at 6 p.m. Central Standard Time. Thank you for joining, Eddie, and all of those that are in other states. Thank you so much. And I'm hoping that this helped you. And remember to click that thumbs up to show me some love and appreciation of what I do here for free. Because soon I'm starting to charge. Not on YouTube, okay? But Tanya, thank you so much. Have a great day. Yes, you too. All right, so on the state, Texas state, we're starting with question number 11, and I do put that on the description. I usually let you know what is happening today. Occasionally, it's incorrect because a typo or copy and paste. So the questions are on page 205 of this particular book by the Metling father and son. And the answers are on page 283. And we're starting with 1211. Okay. So any questions before we start out with the Texas state? Ask about anything. If I don't know the answer, I will Google it. And if I can't find it while I Google it, then I'll Google it more afterwards and get back to you on YouTube or on the Messenger groups. I have 5 different Messenger groups where I send you reminders or share other information. And if you're not in one of those groups, let me know, text me and let me know. I have a Texas group, San Antonio group, Rio Grande Valley group. Actually, I have 2 Texas groups, and then I have one for national for all 50 states. All right, if no questions, we'll continue on here with question 11. Which of the following statements is true? Oh, and we're dealing with Real Estate Commission, Texas Real Estate Commission. Which of the following statements is true regarding license renewals? A, licenses must be renewed every 3 years. B, all licenses expire on December 31st or even number years. C, TREC distributes a notice to renew 3 months prior to expiration. Or D, timely application must be received no later than 30 days before expiration. So which one is a true statement about your Texas real estate license? Type your answer in the chat. Okay, so far I've got C, 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 wee, wee. Anybody else? And yes, the answer is C. TREC distributes a notice to renew 3 months prior to the expiration to give you time to, I got 3 months to finish my 18 hours of renewal. And your first 2 years, though, you have 90 years, okay, of sales apprentice education. 90 hours that has to be completed. So what did I do with those 90 hours? I took a course of 3 sections on it and got a certification. So each course was 30 hours. So I did it on multiple weekends. This was years ago in order to complete. And I did them as soon as possible. So I wouldn't be rushing at the end because it gets really stressful, especially if you're really busy and you're doing awesome in your real estate business. And now you've got to make time to get your hours. So for those 90 hours, I usually recommend start doing them, as soon as possible. Well, when you join any sponsorship, any brokerage, there's going to be training, other education, prepping, your social media, your business logo and websites and all this. So that takes priority. Once you have that in place and you're getting clients, you're lead generating, then start doing your courses. Your 90 hours. That's in the state of Texas. All right, number 12. Oh. A licensee misses the deadline for license renewal. In this case, the licensee has what? A, must retake the license examination and pay the late fees. B, must pay a deferral fee and complete any CE requirements within 60 days. C, must go inactive for a minimum of 90 days. Or D, must resubmit an initial license application, including background checks. Wow, some of them are exaggerated, but that's what happens on exams. There's only one correct answer. What does Texas Real Estate Commission allow when you miss the deadline? It'll cost you more money. That's one thing for sure. Awesome. Very good. So far, we have answered B, B, B. And yes, it is B. Must pay a deferral fee, which is, I think, $200, and complete any CE requirements within 60 days. So let's say your expiration is coming up January 1st, and that happens to be your renewal date, and you don't get it done. You're not ready to complete the 18 hours of renewal. This is after 2 years, right? It could be the 90 also for the first 2 years. Then you can pay a deferral fee, allowing you 2 more months or 60 days to complete those hours. However, that fee has to be paid prior to the expiration date. As long as you pay it prior to the expiration date, then you'll be okay. And within the next 60 days, you submit the credit requirements that TREC requires. So you'll pay the deferral fee, okay, I think $200, plus you'll pay the renewal of your license fee. So you'll end up paying over $400. So very good. BBB, boy, boy, boy. Number 13. Which of the following is true regarding the renewal of an expired license? Okay, so the license expired. What is true? Which one is true? A, renewing applicants do not lose active status if they properly renew within 90 days. B, with a proper application, late renewers filing within 60 days of expiration will not lose active status if sponsored throughout period between expiration and new license issuance. C, expired licenses automatically become inactive. Or D, the license period for the renewal license begins the day the late renewal application was received. So you can have an expired license and still be active. Certain conditions are required, and I just mentioned them in the prior question, or mentioned some. It is not C. They do not automatically become inactive. What did we mention in the prior question? You can extend your period for 60 days to finish your classes. So in that meantime, it expired. However, you're still late because you paid a $200 fee. You paid an option to hold off for 60 days, just like an option in a contract. And if you don't fulfill that within that period, then you lose both the $200 the 240 some odd renewal fee, and you go inactive. So it is not C. It is E. Okay. With a proper application, that is the renewal application to extend it, okay, to defer for 60 days. Late renewers filing within 60 days of expiration will not lose active status if sponsored throughout period between expiration and new license issuance. So when you pay your fee prior to the expiration date, you're allowed 60 days. In that period, you're considered expired. It will not show expired, okay, on your Texas Real Estate Commission website. It will show your expiration date. However, you are still active as long as your license is still under a particular sponsor. Number 14. So good thing you changed the answer. Yes, Delta and Lisbeth. Very good. All right, number 14. Licenses can become inactive for many reasons, 3 of which are listed below. Which statement does not trigger an inactive license? A, the state changes the education requirement for licensees. B, the sponsoring broker moves to a different state. C, the brokerage goes bankrupt. Or D, the licensee applies for inactive status. So which one can become inactive? Which one are listed below, but which one is not an inactive status if it takes place? All right, so far we've got AA. Anybody else? There's quite a few of you in here, so go ahead and type your answer. Take a risk. Life became a risk when the day you were born, says Jim Rohn. He's a motivational, inspirational speaker. All right, so Lisbeth, Cindy, and Delta say A, and we'll go with A. The state changes the education requirements for licensees. That does not trigger an inactive license. Okay, the state will say, hey, next year or from this date on, it'll require 20 credit hours or 21 credit hours. And you did 18, you're still okay. When the renewal period comes, then you'll do the 21 hours. Because at this point, it's 18 hours every 2 years, and that will probably increase. Because the more education is required, oh, I already typed it, the better we know our laws. Because during the renewals, we have to do legal update 1 and legal update 2. So we are up to current laws. Very good, y'all. Number 15. Which of the following are causes for the deactivation of a business entity license? So you want to deactivate a business entity license and go back to an individual license. Which one following are causes? A, the business obtains E&O insurance. B, the entity elects to deactivate. C, the entity fails to complete a transaction in a 12-month period. Or D, the designated broker is promoted to president of the corporation. So which of the following are causes for deactivation of a business entity license? So if a LLC is holding an entity license, a partnership, LLC, corporation, who's in charge of that? Who has the decision to do that? Okay, Ms. Lisbeth has answer B. Anyone else? Type your answer in the chatty chat. Delta B. Come on, Miss Cindy. And whoever else is on here, let us know who you are. Don't be a ghost. Don't be a secret student. Why do I say that? Because in real estate, we see don't be a secret agent. Let everybody know you're a realtor, an agent. And it's not realtor, it's realtor. 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 Yes, the answer is B. The entity elects to deactivate. They're the one that owns the entity. So it's not up to TREC, it's not up to the brokerage, and they inform TREC and make a change application, a change form. Very good. Oh, now I read it correctly. God first, then you. Got it. Number 16. Oh, bummer. It's like somewhere in it. That didn't work. All right, number 16. Which of the following is true regarding the maintenance of one's license status? So remember, these have to do with Texas Real Estate Commission questions. Which one is true regarding the maintenance? How do we maintain our license status? A, deactivating brokers must give sponsored sales agents a 30-day notice from the date of the application. B, a sponsoring broker has to notify TREC a sales agent firing within 1 week of the occurrence. C, to reactivate a broker license, the broker must satisfy all CE requirements and take a 3-hour ethics update course. Or D, to reactivate a sales agent license, licensees must complete a 3-hour legal update course. So which one is a true answer? YouTube, you may have to refresh your page on YouTube because it just went blank and back. And it still doesn't show the whole. Oh, it's still doing the circle. Okay, we have 16A. Anybody else? It is not C. So take another attempt. So which one is true regarding maintaining one's license status? Deactivating brokers must give sponsored sales agents a 30-day advance notice from the date of the application. There's a reason why, right? A sponsoring broker has to notify TREC of a sales agent firing within 1 week of occurrence. C, reactivate a broker license. The broker must satisfy all CE requirements and take a 3-hour ethics update course. Or D, to reactivate a sales agent license, licensee must complete a 3-hour legal update course. No, there's more to it than just 3 hours of ethics update. So the answer here is A. Deactivating brokers must give sponsored sales agents a 30-day advance notice from the date of application. And that's so that those sponsorees can end up start interviewing with other brokerages and have time to change, right? Because they're going to have to, if they go with a different brand name of broker, they'll have to make new signs, new business cards, and change all their websites and social media, a lot of changes. And so interviewing and stuff. So the answer here is 1216A. brokers that are, shutting down their business, deactivating, must give. Okay, must give. So that one has the word must, yet so does C and D. So I wouldn't consider that a keyword to pay attention to. In some answers, yes, when a question has word must and the answer has must, then that's more than likely the answer, and you don't have to, take time to choose one or the other. It's always important to be careful with answers that have always, never, must, okay, because a lot of times those are trigger keywords for a wrong answer. And the word must could be for a correct answer. So number 16 is A. All right, the next test section is standards of conduct in brokerage practice. Standards of conduct in brokerage practice. Number 1, test 13. Licensees must conspicuously display Form 1-1, a consumer disclosure form. Its central message is what? A, licenses should abide by the rule caveat emptor, let buyers beware. B, licensees do not necessarily represent the party who compensates them. C, TREC maintains a recovery fund that may be used to satisfy judgments against licensees who have violated the law. Or D, licensees are not bound by any duty to maintain confidentiality in their dealings with customers and clients. So which one is true about the Form 1-1? Right, so far we've got C. Anyone else? So we've got C, C. I'll give you another moment. And again, anyone watching the replay, hey, just fast forward. Do you want to see the answer right away? Yes, the answer is C. TREC maintains a recovery fund that may be used to satisfy judgments against licensees who have violated the law. It doesn't pay realtors for them having found guilty. It pays the individuals who made the complaint. That's their liquidated damages. And then the realtor has to reimburse TREC for that recovery fund expenditure. So very good. Number 2. Unbeknownst to a buyer, an intermediary informs a seller that the buyer will pay a premium price for the seller's property. Is this an acceptable disclosure? Okay, so buyer doesn't know. We have an intermediary situation. And that intermediary, who is whom? The broker, right? Informs the seller that the buyer will pay a premium price for the seller's property. Is this an acceptable disclosure? So what happens in an intermediary situation? A, yes, since the intermediary represents the seller, he is acting in his seller's best interest. B, yes, since it is common knowledge that the buyer is on a very tight deadline to move in. C, no, since the intermediary did not receive the buyer's authorization to make such a disclosure. Or D, no, since the disclosure violates the agent's fiduciary duty to the buyer. So unbeknownst to a buyer, an intermediary informs a seller that the buyer will pay a premium price for the seller's property. Is this acceptable or not? Is this an acceptable disclosure? So type your answer in the chat. The answer is not D. So type another answer. So is this an acceptable disclosure? Yes, stick with C. The answer is C, no, since the intermediary did not receive the buyer's authorization to make such a disclosure. Remember, the intermediary represents both sides, okay, in the state of Texas. So intermediaries are bound by law to treat transactions principals fairly and honestly. The price disclosure specifically violates rules of conduct for intermediaries. Further, intermediaries are not bound by fiduciary duties. That's the particular realtor that represents each client. And they're not bound by fiduciary duties to a single transaction principal, since he or she effectively represents both parties. So when a broker is the intermediary, they represent both. So the buyer and the seller are under the same umbrella, represented by a buyer agent and the other one by a seller agent, and the broker is on top. They're the intermediary. So they cannot, disclose anything about price. So the realtor themselves that represents a particular principal, if the other agent, informed them of that, or the buyer, well, in this case, the buyer didn't know, then they can disclose that to their principal because they have a fiduciary duty to that one client. However, the broker, intermediary broker, cannot. Number 3, a licensee who is charged with felony fraud pleads no lo contendere, not guilty, okay, or no contest, and all charges are dismissed. So it's no contest. In this case, the licensee, what? So a licensee is charged with felony fraud, pleads no lo contendere, no contest, and all charges are dismissed. In this case, the licensee is what? A, may have license suspended or revoked. B, must notify the real estate commission of the guilty plea. C, is exempted from any commission notification since there was no guilty plea. Or D, has done nothing wrong. So there are certain crucial requirements by Texas Real Estate Commission, right? It is not C. Take another attempt, Lisbeth. And Delta, take another attempt. One of the, whenever you're applying for a real estate license, it asks you of any history, criminal history, right? So TREC requires to know about that. However, it doesn't mean they won't approve the application. They need to know, and then they'll make a determination based on what type of felony or how long ago it was. So the answer is A. They may have their license suspended or revoked. It says may, not that they will. We are not exempt from any commission notification, okay, because there was no guilty plea. They were charged with felony. TREC needs to know. So the answer is A. Okay. They did not plead guilty. They pled no contest. They are charged with felony fraud, but they complete no lo contendere. Okay, no contest. And all charges are dismissed. So if charges are dismissed, they're not found guilty. So in this case, the licensee may have their license suspended or revoked. That'll be up to a TREX review committee. Okay, number 4. Did you get that? Let's see, whoever answered C or B. All right, good, Lisbeth. Thank you for answering that. Okay, number 4. A licensee opts to use a custom design form to transact a residential sale. The contract used was a bona fide sales agreement used extensively prior to the existence of TREC promulgated forms. In this case, the licensee, what? Okay, so it says the licensee they chose to use a custom design form to transact a residential sale. What is one of the major courses that you have to take out of the 6 courses, 30 credit hours? Promulgated contracts, right? The contract used was a bona fide sales agreement used extensively prior to the existence of TREC promulgated forms. In this case, the licensee, what? A, faces legal exposure for the unauthorized practice of law. B, could have their license suspended or revoked. C, may supplant a promulgated form with a previously contract with impunity. Or D, has not committed any violation of license law. So promulgated contract promulgated forms get updated every so often, and especially the contract. So our contract was updated April 1st of 2021. So we must use that new one. So when we opt to use another one, there is a legal new document provided by TREC, which we study 30 hours about promulgated contracts, and that we must use new promulgated forms. Okay, our compliance department will let us know, and some programs will automatically alert you, oh, you're using an old form, update it. We've got to use current forms because some of them are impacted by current law. So the answer is, and if that agent refuses, okay, they may have their license suspended or revoked. So the answer is B. And we've got a question by Delta. It says, why do they update the forms? For the most part, it's because there are state law changes, or there's been concerns from brokers or realtors saying, hey, we need something that is clearer, easier to understand. And they make suggestions, recommendations. It probably goes to the 13-member committee that creates the promulgated forms, and they make a change. So predominantly happen because laws change. And all these are what? Legal documents. However, there are other reasons why some of them change. All right, number 15, and this will be the last question for Texas State. Actually, I shouldn't tell you that so that you don't leave. However, in case you have a timely appointment or something. All right, number 5. Which of the following is a license law violation? License law violation. A, failing to retain trust fund records for the required 6 years. B, advertising listings without an advertising license. C, failing to recommend that a buyer obtain an inspection on a transaction. Or D, failing to disclose a previous license tenancy from another state on the license application. So which one is a license law violation? Remember, disclose, inform, honesty and truthfulness and applications and disclosures. So type your answer in the chatty chat. Okay, so far we have D. And you are the main ones participating. Anyone else? No. Okay, the answer is D, failing to disclose a previous license tenancy from another state on the license application. So Texas Real Estate Commission wants to know that you have a license or had a license from another state. Now, can we have multiple licenses? Yes, we can. Now, does Texas have reciprocation? No. Reciprocation meaning that if you have a license in another state, you can use that license here in Texas. No, we don't have reciprocity. All right, so you got that? So any questions before we call it a day? So I hope that when you're studying, you're repeating the questions over and over until you ace them or get 100 score. I recommend that you get 100 score, okay, whenever possible. And that you're reviewing your vocabulary every day. Because as you notice, these questions have a lot of vocabulary words on there. And when you know the answer to the vocabulary at definition or description, it'll be much easier for you to select the right answer and understand what they're asking for. Okay, so vocabulary, and repeat the same questions over and over and over if you're missing the concepts of that topic or that test. Or go study concepts and review videos that review particular concept that you're having difficulty on. So many of you have issues today on the 4 types of ownership: tenancy by the entirety, tenants in common, and community property or tenant, joint tenancy, tenancy in common. So the 4. So go review the 4 different types of property ownership and review the lessee and estates. Okay, so that was that was test number 12 and the national portion of this book. So rights, interest in estates, and ownership. Delta, you're very welcome. Thank you for attending. Love you all. I appreciate you watching my videos, sending me compliments, comments. Should you ever find anything incorrect, hey, let me know. I will correct it, make an adjustment after I review it to make sure that a comment is correct. And if you have any questions or would like to make comments about how else you would like me to do these classes or what I recommend and how to study, okay, or what I should do different, let me know in the comments. Type it in there. There's been students that have been passing the exam lately, making comments on some of the YouTube channels and also on the messenger groups that I have where I send reminders about an exam or share the actual video after the class. Okay, so you all are welcome, Lisbeth, Delta, Cindy, all of you that attended today. I greatly appreciate you. And my wish for you and my hope is that you study and pass that real estate exam if you can this year, if not, whenever you're ready to take that exam. All right, and until next time, catch you all later. Next time is when? Monday evening at 6 p.m. Central Standard Time. This is Lillie Hendy coming to you with YouTube Agent Prep to help you prepare for your real estate exam, national or Texas State. In San Antonio, Texas, it's where I'm at. Thank you, guys.